Hello, and thank you for joining us. Landegger Verano Davis is an employment law firm with over 40 years of experience exclusively representing employers and business owners. Before we begin, please like our videos, subscribe to our YouTube channel, and turn on the notification bell to receive future video updates. Today, we're going to talk about the new hire package for California employers. We're very happy to have our employment lawyer, Renia Zadourian, presenting this important topic. Renia is an attorney with Landegger Verano Davis and specializes in defending employers, protecting businesses from employee lawsuits, and preventing liabilities of multiple issues. She is a member of the Los Angeles County Bar Association Employment Law Section and received her BA from Cal State Los Angeles and JD from the Thomas Jefferson School of Law. In addition, Renia is fluent in Armenian and the Farsi languages. Here is a 5-star review on Landegger Verano Davis regarding Renia's excellent work. On to you, Renia.
Thank you so much for joining us today. The goal of today's informative video is to help companies that are California employers and are not sure what documents they need to provide when they're hiring a new employee. It is very important for you to know what type of documents you need to provide early on, so longer in the long run you don't come across any types of claims that you could have avoided by just providing them the documents and your policies. So let's get into that and let's just discuss as much as we can in the short amount of time we have with you guys today. So there are two types of things that we need to consider before letting you know what types of documents you need to provide to your employees. Number one is the size of the company. How many employees do you have? Is it more than 50 or is it less than 50? Because if you have 50 and more employees, you're considered a large company. A large company requires additional documentation that your attorney can talk to you and provide you guidance on which documents are additional that you have to provide to them. Just to be brief, it's going to be something that on my PowerPoint, I put it out for you so you can see what documents there are. But my recommendation is for you to talk to an attorney if you are a large company. The 3 points that you can see here, if you have more than 50 employees: family care, medical leave, and pregnancy disability. It's the Fair Credit Report Act, and then the voluntary information that the government requires us for monitoring purposes. These are only applicable for a company that has 50 and more employees. But let's talk about a general form that can show you a checklist of the information that you must provide. So there's a checklist that we tell our clients all the time that can have in front of them when they're dealing with a new hire. This checklist gives you guidance on which documents are mandatory and which are optional. The optional documents are up to you. If your company decides to provide to the new employee, that's just a choice. But the mandatory documents are what you need to provide in order to stay compliant with the law. And you don't have a choice. It's a must. You can see the sample on my PowerPoint. It literally says optional, mandatory, and you can go move forward and check mark on the line and choose whichever one is already provided and what's missing, so you're sure that you're actually staying on top of the new documentations for the new hire employee. Okay, let's start with the first thing that normally the companies provide. This is an optional document, but it's the employee application. So employee has to fill in an application in order to just get started, show the interest that she wants to apply or he wants to apply and wants to become a part of your company. Note that employee application is not a mandatory document. You do not have to have them do an employee application. Number two, notice to employee. Notice to employee is a must. This form is not a choice. You must provide. Labor Code Section 2810.5 requires all types of company owners to provide this to their employees because, number one, it gives them the information regarding their wage and hour, how much they're getting paid, are they on commission or not, the physical address of the employer, workers' compensation information. These are information that the employee comes and gets that paper from you, and she is clear on what to expect as far as where to come to work, what payment she's going to be receiving, and all of that. So this is must. And a lot of companies forget to give the notice to employee, and this is just something that you can avoid a lot of claims in the future. So make sure you provide this form to your new hires. The remaining of the documents on this page, you can see it's the W-4, the I-9 under California state laws. And then what I want to talk about mostly is how to verify the identification of the employee if this employee is remote. All of us know after COVID, it's been very normal for businesses to hire remote employees and that people do not interact in person and you do not have a chance to actually get their verifications, their ID, social security, and how do you stay in compliance with the law if you can't ask for those identification? My answer to you is very simple. You have them, you ask the remote employee to go to a notary and have the notary verify these documents for you. So basically the notary is acting as an agent and they're verifying the documents for you, and you can do this all remotely. You don't have to meet the employee if they're far and if you don't have a chance to see them. Okay, so let's go next. We are talking about workers' compensation. Workers' compensation is one of the documents that workers' compensation, first of all, is mandatory. If you are a company, you need to give workers' compensation to the employees. Why? Because if anyone gets injured at work, you are going to save a lot of money if you have an insurance. If you are covered under workers' compensation, they have to pay for expenses and you don't pay anything out of pocket, and the employee is safe. In something, God forbid, happens, it's just a normal course of work. You have the workers' compensation to give to the employee and they can take care of the medical needs. So make sure you provide workers' compensation information along with other documents that you give them at the time of hire. The next one I want to talk about is benefits. So benefits is something that the employee needs to know when they're getting hired. They need to have a package so they see what type of benefits your company is offering them. The very normal benefits that you as a company have to provide are unemployment insurance, disability insurance, paid family leave, and workforce services. Let me just touch base on a little bit on unemployment insurance. Unemployment insurance basically tells your employee that if anything happens that's outside of our control, it's not up to you, it's not up to us, such as COVID. If that happens, you can get unemployment insurance from state. So they know they have this option. This is not about something happening at work, or it's not a layoff. It's basically layoff due to circumstances that it's outside of your control. The next thing is state disability insurance. Basically, if someone has a non-work related issue, medical issue that they cannot attend to work, they can apply for state disability insurance, and that would give them the peace of mind that they have the money set aside for them in case of emergency and health issues. Paid family leave comes into play when they have a newborn in the family, they have someone that's seriously ill and they need to take care of this immediate family member. So that's something that the employee needs to know at the time of hire, that they have that with your company. Okay, workforce services. This is just about employment services. If they are seeking for a job, if they're out of your company, you're going to give them some additional help. How are you going to give them help to find their next job? Okay, what's the most important today is the sexual harassment documents. We get all types of lawsuits and claims that are regarding sexual harassment. And my number one suggestion for you is please work with an attorney and make sure you get the sexual harassment training to all of your employees, regardless of what you're thinking about it. Sexual harassment training is essential for your business to be protected. And the information you're giving, the time of hire, is very crucial, because you're telling the employee that you're a fair employer, that you care about the company culture, and that sexual harassment is a big policy that you always follow through. It shows them how to report sexual harassment, who to report the sexual harassment to, and if the major issue comes up, how are you going to resolve it as an employer? How is the company going to take care of that? And trust me, this is going to reassure your employee to have more interest in your company and the culture of your company, because it just shows that you care, and it's very important. So make sure you have sexual harassment documents at the time of hire and have them review and sign at the end. Next, I want to talk about meal and rest period violations. Okay, So meal and rest breaks are essential. If we can go back on our, yes, the PowerPoint. So meal and rest period policies are essential for employees to know. Let me give you an example. Meal periods are something the employee has to clock in and clock out. So it's very clear on the records that this person was not working during that time period. However, the rest periods are not that clear. Rest periods are paid time. It's 10 minutes every 4 hours. So after working for 4 hours, the employee under the law can take 10-minute break and they don't have to clock out. So how, in the long run, how do you prove to the court that your employee was able to take the rest breaks if it's not clock in and clock out? This is why it's very important for you to have documents signed by the employee on the day of the hire. Because if they sign, acknowledge that you told them that they must take their break, then at the time when they want to raise a claim, you can show the court and say, Your Honor, I've had this here, and they clearly were aware. They signed it, they dated it, they were aware that they must take their break time. You don't have any responsibility to follow up with them every single day and make sure to tell them, did you take your break? Make sure to take your break. That is not what you need to do. As long as you give them the information and they know they must take it and you can show the court, you are safe. And what we're trying to do here is we're trying to protect you and avoid all the foreseeable claims that can come along the line. Paid sick leave policy. I'm sure when you hire a new employee, they are interested to know if they get sick, what happens to them. Well, under California law, you have to provide a 24-hour, which is a 3-day paid sick leave to your full-time employees. Now, if you're a generous company and if you want to provide them with more, sure, put it in your policy. Make sure they know they get, for example, a week of paid sick leave. But at the very minimum, for you to be compliant with the law, you need to provide them 24 hours. And they need to know that at the time of the hire. You give them a paid sick leave policy, they sign, they acknowledge the receipt of the form, and then you're safe. And lastly, I want to talk about employee handbook. The employee handbook is crucial because it shows the employee what the culture of your firm is, your company is. How are you going to treat every single scenario? How are they going to dress up for work? What are the rest periods? All of these policies that we talked about so far, you can include it in employee handbook. An employee handbook is very customized document that you provide to your employee based on the culture of the company, the mission, the vision of the company. And normally what we do is we consult with our clients. We talk to the company owners and tell them what's normally part of an employee handbook and what they can add as additional parts of policies and procedures. But what it does mainly is communicates to the employees about what is expected of them. So if they don't have an employee handbook, there is nothing written and there's nothing that can secure you to show later on if any claims arises from this type of employment relationship to protect you. So it's an absolute must. If you don't have an employee handbook, that is something that you want to get on as soon as possible. If you have some employee handbooks, if you don't know if it's completely compliant with law, you can send it to your attorney. They can review and give you your feedback. With this being said, it also shows your employees that you had reasonable care for them. You cared about them. You were hiring them. You're giving them everything they need. You're welcoming them to the company, and you're safe. They're happy. It's a win-win situation. Thank you so much for listening today. I hope I can provide you with more next time, but we have a limited time today. I can't wait to have more videos and more information for you all. Thank you. And if you want to contact me, you can email me at renia@landegger.ask.com, or you can also give me a call anytime and I will be available to answer your questions. Have a great day.